Before we begin, a quick and important disclaimer. This documentary is intended for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. The processes and economic outcomes discussed are based on historical trends and general case studies within the United States legal system. Because family law varies significantly by jurisdiction and individual circumstances, viewers must conduct their own due diligence and consult with qualified legal and financial professionals regarding their specific situation. Imagine a scenario where you are forced to take a significant portion of your net worth, your retirement savings, your home equity, and your children's college funds, and set it on fire in a public square. For hundreds of thousands of Americans every year, this isn't a metaphor. It is the reality of the traditional litigated divorce. We are currently witnessing a systemic wealth transfer in the United States, where the adversarial legal process acts as a vacuum, sucking liquidity out of middle-class and high-net-worth households and depositing it directly into the billable hour ledgers of the legal industry. The average cost of a contested divorce in the U.S. now ranges from $15,000 to over $100,000 per person, depending on the complexity of the assets. But there is a silent alternative that the traditional litigation machine rarely highlights. A method that doesn't just save money, but preserves the underlying economic engine of the family unit. This is the deep dive investigation into the economic value of divorce mediation, a masterclass on why how you end a marriage might be the most important financial decision of your adult life. Today, we are breaking down the wall of the divorce industrial complex. If you are a resident of the United States navigating the end of a partnership, you are facing a fork in the road. One path leads to a courtroom where a stranger in a black robe decides the fate of your 401k. The other leads to a conference table where you retain control over every cent. By the end of this documentary, you will understand the granular math behind mediation, the hidden litigation tax that most people pay without realizing it, and the step-by-step framework for protecting your generational wealth during a transition that typically destroys it. To understand the economic value of mediation, we must first quantify the destruction caused by its opposite, the adversarial model. In a traditional litigated divorce, the system is built on a zero-sum philosophy. For one party to win $1, the other must lose $1. However, this math is fundamentally flawed because it ignores the friction costs. When two parties hire opposing counsel to fight over a $500,000 asset pool, they aren't just splitting $500,000. They are paying for retainers, expert witnesses, forensic accountants, and court filing fees. If each side spends $50,000 on legal fees, a conservative estimate for a trial, the total asset pool has already shrunk by 20% before a single distribution is made. The economic value of mediation starts with the elimination of this friction tax. In mediation, a neutral third party facilitates a negotiation between the spouses. Instead of two lawyers communicating through formal motions and discovery requests, which can cost thousands of dollars in billable hours just to exchange bank statements, the parties sit in a room and exchange information directly. This transparency drastically reduces the time to resolution metric. In the U.S. court system, a contested divorce can languish on a docket for 18 to 36 months. During this time, the parties are often in a state of financial paralysis, unable to sell property, refinance debts, or move forward with investments. Mediation, conversely, can often be completed in 3 to 6 months. From an economic standpoint, the opportunity cost of being stuck in litigation for 2 extra years is staggering. If you have $200,000 tied up in a disputed brokerage account that you cannot manage or rebalance because of a court injunction, you are losing the potential market gains and dividends of that capital. Let's look at a case study comparing Spouse A and Spouse B. They have a combined net worth of $1.2 million, including a primary residence with $400,000 in equity. In a litigated scenario, they spend 18 months fighting over the valuation of the home and the division of a small business. By the time they reach a settlement on the courthouse steps, they have collectively spent $120,000 in legal fees. Their net marital estate has dropped to $1.08 million. Furthermore, because the process took so long, they missed a window to sell the home during a peak market cycle, resulting in an additional $40,000 loss in potential equity. Now, consider the mediation alternative for that same couple. They hire a qualified mediator for a flat fee or an hourly rate that is shared. Total cost, $8,000. They reach an agreement in 4 sessions. Their marital estate remains at $1.192 million. The economic value added by choosing mediation in this single instance is $112,000. That is money that stays in their pockets, goes toward their children's education, or remains in their retirement accounts to compound over the next 20 years. If that $112,000 is invested at a 7% annual return, it grows to over $430,000 in 20 years. Choosing litigation didn't just cost them $120,000 today. It cost them nearly $500,000 in future wealth. The value proposition extends far beyond the direct savings on attorney fees. We have to discuss the tax efficiency of mediated settlements. In a courtroom, a judge often uses a sledgehammer approach to asset division to clear a crowded docket. They might order the immediate sale of an asset, triggering significant capital gains taxes that neither party wanted to incur. In mediation, the parties have the surgical flexibility to structure their settlement in a way that minimizes the tax burden. For example, they can decide to offset the value of a house with the value of a retirement account, accounting for the deferred tax liability of the 401k. A mediator helps the parties look at the after-tax value of their assets. This level of nuance is rarely achieved in the heat of a trial, where the focus is on winning the argument rather than optimizing the balance sheet. Furthermore, mediation allows for creative cash flow modeling. In a U.S. divorce, alimony, spousal support, and child support are often calculated using rigid state guidelines. While these formulas provide a baseline, they don't always reflect the actual cash flow needs or tax realities of the family. Mediation allows parents to create education trusts or variable support schedules that align with their actual income fluctuations, such as bonuses or seasonal business revenue. This prevents future legal relitigation costs. Every time a party has to go back to court to modify an order because the original one was poorly structured, it costs an average of $5,000 to $10,000. Mediation builds a durable agreement that stands the test of time, providing long-term economic stability. We must also address the human capital element. Divorce is a high-stress event that significantly impacts professional productivity. Data suggests that employees going through a contested divorce see a precipitous drop in work performance, leading to lost promotions, reduced bonuses, or even job loss. The adversarial nature of litigation creates a cognitive load that makes it nearly impossible to focus on career growth. By choosing a collaborative, private, and faster process like mediation, individuals can preserve their human capital, their ability to earn and grow their income. As we move through this documentary, we are going to pull back the curtain on how to select a mediator, how to prepare your financial disclosures to minimize billable time, and how to handle the power imbalances that often lead people back to the expensive arms of litigators. We are moving away from the emotional cost and focusing strictly on the balance sheet of the American family. If you view your divorce as a business dissolution, mediation is the only logical path to maximize the residual value of your life's work. This is not just about getting along. It is about the cold, hard math of wealth preservation in a system designed to tax your conflict. To grasp the sheer scale of the economic delta between litigation and mediation, we have to look at the anatomy of a legal bill in the year 2026. In the United States, the traditional billable hour model creates an inherent conflict of interest between the efficiency of the resolution and the profitability of the firm representing you. Imagine a couple in Austin, Texas, whom we will call Michael and Sarah. They have been married for 15 years and have accumulated a suburban home, 2 high-yield savings accounts, and significant equity in a mid-sized tech consultancy. When they decide to part ways, they initially choose the adversarial route. Each hires a top-tier firm with a $5,000 initial retainer. Within the first 60 days, the economic erosion begins. Every email sent between their attorneys is billed in 6-minute increments. Every phone call to discuss a minor scheduling conflict for a deposition is billed at $450 an hour. By the time they reach the discovery phase, where each side demands 3 years of tax returns, credit card statements, and utility bills, Michael and Sarah have already spent $24,000 combined. This is before a single negotiation has occurred. In the litigation model, you are paying for the process of fighting, not the result of settling. Historical trends show that roughly 90% of divorce cases in the U.S. eventually settle before trial, but they often do so only after the parties have exhausted a significant portion of their liquid assets on the pretrial maneuvers that lead up to that moment. Mediation flips this financial script by front-loading the settlement and eliminating the performative aggression of legal correspondence. In a mediation session, Michael and Sarah sit with a neutral professional whose goal is not to win, but to close the gap. Instead of two lawyers spending 3 hours drafting a motion to compel discovery, the mediator asks the parties to bring their laptops to the table and log into their accounts in real time. The economic value here is found in the compression of billable events. A task that takes 12 billable hours in a contested litigation environment can often be resolved in 90 minutes of mediated dialogue. For Michael and Sarah, this shift in strategy represents a potential savings of over $80,000 in the first 6 months alone. Let us dive deeper into the concept of the valuation of intangible assets. In the U.S. economy of 2026, wealth is no longer just about physical property or gold. It is about intellectual property, stock options, and restricted stock units. When a court is tasked with valuing these assets, it often requires the appointment of a court-certified forensic evaluator. These experts can charge upwards of $10,000 for a single report. In a litigated battle, if spouse disagrees with the court expert, they hire their own rebuttal expert for another $10,000. Now, $20,000 of the family's net worth has vanished just to determine the hypothetical value of a private business. In a masterclass on mediation, we analyze how a neutral expert can serve both parties simultaneously. Instead of two competing experts, the parties in mediation agree on one joint neutral evaluator. This person provides a single objective range of value. By cutting the expert witness costs in half and removing the need for expert testimony at a trial, which can cost $3,000 to $5,000 per day per expert, the parties preserve the very equity they are trying to divide. Historical case studies indicate that joint neutrals provide valuations that are often more accurate because they have full cooperation from both spouses, rather than having to hunt for information hidden by a defensive litigant. Beyond the direct costs, there is the massive, often overlooked category of tax optimization. In a courtroom, a judge is bound by state statutes that prioritize equitable or community property distribution, often without regard for the immediate tax consequences. If a judge orders the sale of a brokerage account to satisfy a lump sum payment to a spouse, that sale might trigger a massive capital gains tax event. If that sale happens in a high-income year for the couple, they could lose 20 to 30% of that asset to the IRS. In mediation, Michael and Sarah have the autonomy to use Internal Revenue Code Section 1041. This allows for the transfer of property between spouses incident to divorce without recognizing a gain or loss for tax purposes. A mediator helps the parties identify which assets have a high tax basis and which have a low tax basis. They can structure a trade where one spouse takes the cash in a savings account, which has no tax liability, while the other takes a stock portfolio with a similar current value but a built-in tax liability for the future. By balancing the after-tax value rather than the gross value, the couple effectively keeps more of their total wealth within the family unit rather than gifting it to the government through poor planning. Another critical economic factor is the preservation of credit scores and financing ability. During a 2-year litigated divorce, many couples stop communicating about joint debts. Missed mortgage payments or late credit card bills during the pendant light period, the time while the divorce is pending, can tank both parties' credit scores by over 100 points. In 2026, with interest rates fluctuating, a lower credit score could mean the difference between a 4% mortgage on a new home and a 7% mortgage. Over a 30-year loan, that 3% difference on a $400,000 house amounts to over $250,000 in extra interest payments. Mediation addresses this by creating an immediate interim financial agreement. Within the first 2 weeks, a mediator helps the couple establish a status quo budget. They agree on who pays which bill and from which account, ensuring that the financial infrastructure of both individuals remains intact throughout the transition. The economic value of maintaining a prime credit score during a divorce is a hidden windfall that litigation almost never protects. Imagine if you could avoid the documentary gap. In litigation, your private financial life becomes a matter of public record. Your business's profit and loss statements, your spending habits, and your debts are filed in a courthouse where they can be accessed by competitors, predatory lenders, or nosy neighbors. This lack of privacy can have a direct negative impact on the valuation of a business or your professional reputation. Mediation is a confidential process. The documents exchanged and the discussions held are legally privileged in most U.S. states and cannot be used in court if mediation fails. This privacy protects the goodwill value of your professional life, which is an asset that, once damaged, is nearly impossible to recover financially. As we look toward the next phase of this deep dive, we have to address the most significant financial risk of all: the winner's curse in the courtroom. When a judge makes a final ruling, one side often feels economically devastated, leading to a cycle of appeals that can last for years and cost tens of thousands more. In mediation, because the parties co-create the solution, the compliance rate is significantly higher. But what happens when one spouse is hiding assets? What happens when the power dynamic is so skewed that one person feels they can't negotiate fairly? In the next part, we will expose the specific financial forensics used in mediation to ensure that fair isn't just a feeling, but a verifiable mathematical reality. We will look at how to spot the red flags of financial non-disclosure before you sign a single document. To master the economic value of mediation, we must confront the most common fear in the American divorce landscape: the fear of the hidden offshore account, the deleted crypto wallet, or the undeclared cash business. In a litigated environment, the hunt for these assets is called formal discovery. It is a process governed by the rules of civil procedure, involving subpoenas, depositions, and motions to compel. Historically, this is where the financial drain accelerates exponentially. A single deposition of a spouse can cost $4,000 in stenographer fees and attorney prep time, often yielding nothing but more questions. In 2026, the economic value of mediation is redefined by a process called voluntary disclosure, which operates on a principle of verified transparency rather than adversarial extraction. Imagine a husband in Seattle named David, who has been a high-level software architect for a decade. His wife, Maria, suspecting he might have diverted funds into digital assets, pushes for a forensic audit. In a litigation track, David's attorney would likely fight the scope of the audit, leading to months of legal sparring. In mediation, a sophisticated neutral financial professional, often a certified divorce financial analyst or CDFA, is brought into the room. Instead of David being interrogated by a hostile lawyer, the CDFA sits with both David and Maria to map out the digital footprint of their marriage. This financial neutral uses a step-by-step verification protocol. First, they cross-reference 3 years of joint tax returns with bank statement inflows. If David's reported salary was $300,000, but only $250,000 appeared in the joint accounts, there is a $50,000 delta that must be accounted for. In mediation, this isn't framed as a crime, but as a mathematical discrepancy to be solved. David might explain that the funds went into a dedicated investment account or a crypto exchange. Because the setting is non-adversarial, David is more likely to provide the login exports for his Coinbase or Kraken accounts immediately, rather than waiting for a court order. The economic value here is the avoidance of the discovery war. By resolving this discrepancy in a 2-hour mediation session instead of a 6-month court battle, the couple saves an estimated $30,000 in forensic accounting fees and legal arguments. The verification process in mediation also utilizes what we call the lifestyle analysis. This is a powerful economic tool where the mediator or financial neutral looks at the family's historical spending. If the couple spent $120,000 last year on mortgage, travel, and insurance, but their declared income after taxes was only $90,000, the math dictates that there is an undisclosed source of liquidity. This forensic sniff test is just as effective in a conference room as it is in a courtroom, but it costs 75% less to perform when the parties are cooperating with a single neutral rather than fighting two separate ones. Case studies from 2025 and early 2026 show that the success of this transparent model relies on the mediator's ability to use carrots rather than sticks. The incentive for David to be honest is the speed of his own financial liberation. If he discloses the assets, the mediation moves toward a global settlement. If he hides them and is caught, which in the era of AI-driven financial tracking is an historical trend of high probability, the mediation terminates, and he is thrust back into the high-cost litigation machine where he will likely be sanctioned by a judge. The economic value of mediation is therefore a honesty dividend. Now, let us look at the complexity of the modern American portfolio, specifically the 2026 volatility in the housing market. For most families, the primary residence is their largest illiquid asset. In a typical litigated divorce, the house is a battleground. One spouse wants to keep it, the other wants to sell it to get their half of the equity. A judge, lacking the time to manage your private life, will frequently order the house to be sold within 90 days. This is an economic disaster. A forced sale in a 90-day window often means accepting a lower price, paying a full 6% realtor commission, and potentially moving out during a period of high rental costs or unfavorable mortgage rates. In mediation, we explore the economic value of optionality. Imagine if Maria wants to stay in the house so the children can finish high school. In a courtroom, David's lawyer would argue this is unfair because David needs his equity now. In mediation, they can construct a deferred equity buyout. They might agree that Maria stays in the house for 3 years, but David's equity is locked in at a specific dollar amount or a percentage of future value. They might even agree to a shared equity model where David continues to pay a portion of the mortgage in lieu of higher spousal support, allowing him to keep a tax deduction while Maria maintains stability. By avoiding the forced sale, the family saves the immediate 6% commission, which on an $800,000 home in a city like Denver or Charlotte is $48,000. They also avoid the capital gains trap. Under current U.S. tax law, a married couple can exclude $500,000 of gain on a primary residence sale. If they divorce and then sell as single individuals later, they may only be able to exclude $250,000 each. Mediation allows them to time the sale or structure the transfer while they are still legally married, or within the tax-protected window of the divorce decree, potentially saving them tens of thousands in federal taxes. There is also the step-by-step debt restructuring value. When a court splits a family in two, it often leaves both parties with half the debt, but only half the income. This is why we see a historical trend of post-divorce insolvency in the United States. Mediation focuses on the sustainability of the result. The mediator looks at the debt-to-income ratio of both parties after the split. They might suggest that spouse A takes a larger share of the retirement assets while spouse B takes the liquid cash to pay off a high-interest car loan or credit card. This isn't about being nice. It is about ensuring that neither party defaults on their obligations, which would lead to legal fees for the other party later when support payments stop. We have to consider the value of time, value of money. In litigation, you are fighting for today's dollars with tomorrow's uncertainty. In mediation, you are reaching a settlement today that can be put to work immediately. If a mediation saves you 18 months of conflict, it is giving you 18 months of compound interest. For a couple with $1 million portfolio, that year and a half of settled status allows them to move their capital into the most efficient tax buckets for their new single lives. As we progress through this masterclass, we have to address the psychological pivot that makes this economic value possible. Many people believe they need a bulldog lawyer to protect their money. But in reality, the bulldog lawyer often eats the very meat they are supposed to be guarding. In the next section, we are going to break down the mediation readiness checklist. We will show you exactly how to organize your 2026 financial data before you meet a mediator, so that you can reduce your professional fees by another 30%. We will also dive into the calculated risk of the no agreement scenario. What happens if you go through mediation and it fails? Is that money wasted? The answer involves a hidden benefit that most people never realize until they are in the thick of it. The fear that mediation might result in a total loss of investment if a final agreement isn't reached is one of the primary reasons many Americans default to the litigation track. However, this perspective overlooks the concept of narrowing the issues, which is a significant economic benefit even in partially successful sessions. In the U.S. legal system of 2026, a divorce isn't just one big argument. It is a collection of dozens of micro-disputes regarding asset valuation, debt allocation, parenting time, and support obligations. If you enter mediation with 20 disputed points and leave with 15 of them resolved, you have effectively eliminated 75% of the future billable hours your attorneys would have spent on those specific topics. Imagine a couple in Phoenix named Jennifer and Robert. They have a complex estate including a primary residence, 2 vacation rentals, several retirement accounts, and a disagreement over the custody schedule for their 3 children. They spend 3 sessions in mediation. They successfully agree on the value of the real estate and the division of all bank accounts. However, they reach a stalemate regarding the long-term alimony amount and the summer holiday schedule. In a traditional mindset, Jennifer might feel that the $3,000 spent on the mediator was wasted because they still have to go to court. But the math tells a different story. Because they reached a partial agreement, their attorneys no longer need to conduct discovery on the bank accounts, hire real estate appraisers, or draft motions regarding the division of the vacation rentals. By narrowing the scope of the trial to just 2 issues instead of 12, Robert and Jennifer have reduced their potential trial costs from an estimated $60,000 down to $15,000. This is the partial success dividend. The step-by-step logic of mediation prep is the next pillar of our economic masterclass. To maximize the value of every minute in the mediation room, a participant must act as their own paralegal. In 2026, data organization is the ultimate cost saver. The first step is the creation of a comprehensive asset map. This is not just a list of accounts. It is a live document that includes the current balance, the tax basis, the date the account was opened, and the source of the funds. When a party walks into mediation with a neatly organized digital folder containing 3 years of statements for every account, they are effectively cutting out the 5 to 10 hours of time a mediator or attorney would spend hunting for that data. At an average rate of $300 to $500 an hour, that single act of organization saves the household up to $5,000. Next, we must look at the case study of the premarital asset. One of the most expensive things to litigate in the United States is the commingling of separate property. If Robert owned a condo before the marriage and sold it to put a down payment on the family home 10 years ago, determining what portion of the current home equity is his separate property and what is marital property requires a complex calculation known as a tracing analysis. In a litigated setting, attorneys will argue over the methodology for months. In mediation, the parties can agree to use a standard formula, such as the Moore-Marsden calculation often used in community property states, to reach a practical number in 30 minutes. By choosing a formulaic approach over a litigated one, the couple avoids the cost of a forensic accountant's testimony, which typically carries a high daily retainer. Historical trends in the U.S. show that the most successful mediation participants utilize the shadow counsel strategy. This is an essential nuance for high-retention financial planning. While the mediator is a neutral party who cannot give individual legal advice, each spouse can hire an attorney to act as a consultant in the background. Instead of the attorney leading the charge and billing for every interaction with the other side, they stay behind the scenes, reviewing the draft agreements produced in mediation. This allows Jennifer and Robert to have the protection of legal oversight at a fraction of the cost. They are paying for a few hours of review time rather than hundreds of hours of litigation management. This hybrid model provides the safety of the legal system with the efficiency of the mediation table. Furthermore, we must address the economic value of the parenting plan. While it may seem like a social or emotional issue, custody is a massive driver of divorce costs in the United States. In a contested custody battle, the court may appoint a guardian ad litem or a custody evaluator. These professionals conduct interviews, visit homes, and write massive reports. The cost for these evaluations in 2026 often starts at $15,000 and can exceed $50,000 in high-conflict cases. Mediation allows parents to bypass this entire expense. By using a step-by-step interest-based negotiation, parents can build a schedule that focuses on the child's needs and the parent's work realities. The money saved on a custody evaluator is money that can be redirected into a $529 college savings plan for the child. Imagine if the money normally spent on experts was instead used to seed a post-divorce emergency fund. For many American families, the first year after divorce is the most financially precarious. There are new deposits for apartments, the cost of splitting one household's utilities into two, and the loss of economies of scale. By choosing mediation, the average middle-class couple in the U.S. can preserve between $20,000 and $40,000 of liquidity. This serves as a vital cushion that prevents the need for high-interest credit card debt during the transition. The economic value here isn't just the absence of legal fees. It is the presence of capital at the most critical moment of a family's financial restructuring. We also need to discuss the concept of the Rule of 72 in the context of divorce. This is a simple way to determine how long it will take for an investment to double. If a couple saves $50,000 by choosing mediation and invests that money in a diversified index fund with an average annual return of 7%, that money will double in approximately 10 years. By the time their children reach college age, that mediation savings could have grown to $100,000 or more. Conversely, if they spend that $50,000 on litigation, they aren't just losing the $50,000, they are losing the future growth of that money. Litigation is a double spend. You pay the bill today, and you pay the lost opportunity cost for the rest of your life. As we move deeper into this documentary, we must confront the reality of the stalemate. Even with the best preparation, some mediations hit a wall. In the next part, we are going to explore the advanced negotiation tactics used by the world's top mediators to break through financial deadlocks. We will look at the bracketed settlement technique and the use of contingent agreements to solve the problem of uncertain future income. We will also reveal the one specific question you must ask a potential mediator before you hire them to ensure they have the financial acumen to handle a complex 2026 portfolio. What happens when the numbers simply don't add up? The answer lies in a technique borrowed from high-stakes corporate mergers. The technique borrowed from high-stakes corporate mergers is known as the contingent value right, or in the world of U.S. family law, the step-up agreement. In a traditional courtroom setting, a judge is forced to make a determination based on the facts as they exist on the day of the trial. If a spouse is currently unemployed or a business is experiencing a temporary downturn, the judge must set support or valuation based on that snapshot in time. This creates an enormous economic risk for both parties. If the support is set too low, the recipient spouse may face insolvency. If it is set too high based on a temporary peak in income, the paying spouse may be forced into a modification suit that costs another $10,000 in legal fees. In mediation, we use the economic principle of the bracketed settlement. Imagine a character named Marcus in Chicago. Marcus is a senior executive at a logistics firm, and in 2026, his income is heavily dependent on annual performance bonuses that fluctuate based on global supply chain health. His wife, Sarah, needs a stable income to maintain their home. Instead of fighting over a fixed number that might be obsolete by 2027, they use mediation to create a tiered support structure. They agree on a base level of support that covers essential needs, but they build in a percentage-based formula for any income Marcus earns above his base salary. By using this bracketed approach, they eliminate the need for future litigation. Historical trends show that families who use formulaic, self-adjusting support agreements are 60% less likely to return to court for modifications. For Marcus and Sarah, the economic value is twofold. They avoid the immediate $30,000 cost of a trial to determine a fixed number, and they save an estimated $15,000 in future legal fees because their agreement already contains the instructions for how to handle a raise or a bonus. This is a level of financial engineering that is rarely available in the rigid environment of a state court docket. Now, let us examine the specific financial acumen you must look for when selecting a mediator for a complex 2026 portfolio. Not all mediators are created equal. Some come from a social work background and focus primarily on emotional communication, while others are retired judges or financial specialists. To maximize economic value, you must screen for a mediator who understands the specific tax implications of the current year's fiscal policy. For example, if you have a significant position in decentralized finance assets or staked cryptocurrency, you need a mediator who understands the difference between a taxable event and a mere transfer of custody. If a mediator treats a Bitcoin wallet the same way they treat a standard savings account, they are potentially leaving a massive tax liability on the table for whoever receives that asset. In a case study from early 2026, a couple divided their assets 50-50 based on current market value. However, the spouse who received the crypto assets inherited a near zero cost basis, meaning that when they eventually sold the assets to buy a home, they were hit with a six-figure capital gains tax bill. The spouse who took the cash walked away with a true 100 cents on the dollar. A financially savvy mediator would have suggested a tax-adjusted division, where the spouse taking the high tax liability asset receives a larger gross percentage to compensate for the future tax haircut. The next step-by-step detail involves the use of the QDRO, or Qualified Domestic Relations Order. This is a specialized legal instrument used to divide retirement accounts like a 401k or a pension without triggering early withdrawal penalties or immediate income tax. In a litigated divorce, the QDRO process is often an afterthought, occurring months after the divorce is finalized. This delay can be economically devastating. If the market drops 20% between the date of the divorce decree and the date the QDRO is finally processed by the plan administrator, the recipient spouse may lose tens of thousands of dollars in value. In a mediation masterclass, we teach the concurrent processing model. This means that while the mediation is ongoing, the parties have already contacted their plan administrators to obtain the specific required language for the QDRO. They may even have a draft order ready for the judge to sign the same day the divorce is granted. This speed protects the parties from market volatility. If you are dividing a $500,000 401k in 2026, a 3-month delay in a volatile market could cost you more than the entire cost of the divorce itself. By prioritizing the technical execution of the asset transfer alongside the negotiation, mediation provides a level of risk management that adversarial litigation simply cannot match. Furthermore, let us look at the economic value of the neutral business valuation. In the United States, many small business owners mistakenly believe that the book value of their company is what will be used in a divorce. In reality, a court often looks at fair market value or the capitalization of earnings. In litigation, each side hires their own valuation expert. These experts often produce reports that are hundreds of thousands of dollars apart, leading to a battle of the experts that can cost $50,000 just in expert fees. Imagine a scenario where Sarah owns a boutique digital marketing agency. In mediation, she and Marcus agree to hire one joint neutral appraiser. This professional provides a range of values based on historical trends and potential outcomes for the industry in 2026. Because the appraiser is working for both parties, their report is viewed as more objective. The parties then use that report as a starting point for a trade. Perhaps Marcus waives his interest in the business in exchange for a larger share of the home equity, or a reduction in his spousal support obligations over time. This trade-off is the essence of mediation value. It allows for the preservation of a cash-flowing asset, the business, while ensuring both parties receive an equitable share of the total net worth. We must also address the hidden cost of the discovery gap in the U.S. When attorneys engage in formal discovery, they often demand every single receipt and bank statement for the last 5 years. This is not just a legal cost. It is a massive labor cost for the parties themselves. Case studies show that the average person spends over 40 hours of their own time gathering, scanning, and organizing documents for their attorney. If you value your time at even $50 an hour, that is $2,000 of lost productivity. Mediation encourages a targeted disclosure approach. Instead of a fishing expedition, the mediator helps the parties identify exactly which documents are necessary to make an informed decision. This streamlined approach respects the parties' time and preserves their energy for their careers and families. As we reach the midpoint of this deep dive, we have established that mediation is not just a way to be nice. It is a sophisticated financial strategy for wealth retention. But what happens when the emotional tension is so high that the parties cannot sit in the same room? Does the economic value of mediation vanish when the conversation breaks down? In the next part, we will explore the shuttle diplomacy model and the use of caucusing. We will look at how high-conflict couples are still achieving massive financial savings through remote and asynchronous mediation techniques. We will also dive into the specific language you should use in a mediation session to pivot the conversation from emotional grievances back to the balance sheet, ensuring that your billable time is never wasted on the past, but invested in your future. The pivot from emotional grievances to the balance sheet is where the majority of the economic value is salvaged in high-conflict scenarios. In the professional mediation world of 2026, this is achieved through a technique called the economic interest pivot. When one party brings up a past betrayal or a personality conflict, the mediator does not shut the conversation down. Instead, they translate that emotional need into a financial metric. For example, if a spouse is expressing anger over a partner's past spending habits, the mediator redirects the focus toward the remaining marital liquidity and how that liquidity will be partitioned to ensure both parties have a sustainable start. This translation prevents the session from devolving into a $300 an hour venting session, which is a common occurrence in litigated depositions where every word is transcribed and every emotion is weaponized for future trial testimony. Shuttle diplomacy and caucusing represent the primary structural tools for maintaining economic progress when face-to-face interaction becomes counterproductive. In a caucus, the mediator places the parties in separate digital or physical rooms and moves between them. This is not just a comfort measure. It is a tactical financial maneuver. By separating the parties, the mediator can explore the true settlement ranges of each person without the fear of immediate emotional blowback. This process allows for a rapid exchange of settlement offers that might take weeks to filter through attorneys in a litigation track. Imagine a couple in Atlanta named Thomas and Elena. They have been at a standstill for 4 months regarding the division of a high-value art collection and several income-producing rental properties. Every time they meet, the conversation breaks down over who deserves more for maintaining the properties over the last decade. In mediation, the mediator moves Thomas into a caucus and asks him to define his walk-away number, the absolute minimum he needs to feel secure. Then, the mediator does the same with Elena. Often, the mediator discovers that the parties are only $50,000 apart on a $2 million estate. In a courtroom, they would spend $100,000 in legal fees to fight over that $50,000 gap. In the caucus, the mediator can present a split-the-difference proposal, or a creative asset swap that closes the gap in 30 minutes. The economic value of the caucus is its ability to bypass the ego-driven roadblocks that frequently drive litigation costs into the stratosphere. Asynchronous mediation is another 2026 innovation that is drastically reducing the cost of divorce for U.S. households. In this model, the parties do not have to be online at the same time. They use secure portals to review financial disclosures, ask questions, and leave comments on draft agreements. This eliminates the need for 4-hour blocks of time where everyone is billed simultaneously. If Elena has a question about the tax basis of a specific REIT in their portfolio, she posts it in the portal. The mediator or the financial neutral answers it when they are at their desk, and Thomas reviews it after work. This model reduces the billable hour friction and allows the parties to process complex financial information at their own pace, leading to more informed and durable decisions. One of the most significant historical trends we are observing in 2026 is the rise of the unbundled legal services model, used in conjunction with mediation. Instead of hiring a full-service litigation firm with a $20,000 retainer, savvy Americans are hiring attorneys for specific tasks, a process often called limited scope representation. An individual might hire an attorney for 2 hours to review a mediated settlement agreement, or for 3 hours to draft the final judgment of divorce based on the mediator's memorandum of understanding. By unbundling the services, the total legal spend often drops from $30,000 to under $5,000. This strategy ensures that the legal protections of the state are still in place, while the heavy lifting of the negotiation is done in the more cost-effective mediation environment. Let us look at a step-by-step detail regarding the drafting of the Memorandum of Understanding, or MOU. The MOU is the document produced by the mediator that outlines every agreement reached during the sessions. In mediation, you are paying for a professional to capture the spirit and the letter of your agreement in real time. In litigation, the final order is often drafted by the winning attorney, then reviewed and redrafted by the losing attorney, then revised by the judge. This back-and-forth drafting process can cost $5,000 to $10,000 in billable time alone. In mediation, the parties see the MOU being typed on a screen as they speak. They can correct errors, clarify intent, and ensure the numbers match their expectations immediately. This real-time drafting is an economic safeguard against the drafting errors that frequently lead to post-divorce litigation. The economic value of mediation also shines in the context of the 2026 labor market. For professionals with restricted stock units, performance shares, or complex vesting schedules, the way these assets are handled can mean a difference of hundreds of thousands of dollars. Litigation often treats these as simple assets to be divided upon vesting. However, mediation allows for more complex, if and when structures. For instance, Thomas might agree to pay Elena a percentage of the net proceeds of his RSUs as they vest, but in exchange, Elena agrees to take a smaller portion of the current liquid savings. This allows Thomas to maintain his upside potential in his company, while providing Elena with a predictable future cash flow. This kind of custom-tailored financial engineering is a hallmark of the mediation masterclass, and is almost impossible to achieve in a court-ordered judgment, where the judge simply doesn't have the time to model out 5 years of vesting schedules. Furthermore, consider the case study of the midlife career pivot. In 2026, it is common for individuals to return to school or start a business post-divorce. Mediation can build in rehabilitation alimony that is specifically tied to educational milestones, rather than a flat monthly fee for an indefinite period. By tying support to specific economic outcomes, the parties create a shared interest in each other's success. This reduces the economic hostility that often defines the post-divorce relationship. When both parties feel the settlement was fair and structured for their future growth, the likelihood of deadbeat scenarios, where one party stops paying because they feel the system is unfair, drops significantly. This saves both parties from the future costs of contempt of court hearings and wage garnishments. The economic value of mediation is a cumulative effect. It is the sum of the saved attorney fees, the avoided tax liabilities, the preserved credit scores, and the retained human capital. It is a protective barrier around the family's net worth. But as we move toward the final sections of this documentary, we must address the final hurdle: the actual filing of the paperwork. Many people successfully mediate their agreement, but then stumble at the courthouse steps, leading to delays that can trigger unexpected financial consequences. In the next part, we will break down the zero-friction filing process. We will show you how to navigate the 2026 electronic filing systems in major U.S. jurisdictions to ensure your mediated agreement becomes a legally binding judgment in record time. We will also reveal the post-mediation audit, the critical steps you must take in the first 30 days after your divorce is final to lock in your financial gains and prevent asset leakage from forgotten accounts and untransferred titles. The transition from a signed mediation agreement to a legally binding court order is often where the most significant administrative friction occurs in the United States. In the legal landscape of 2026, many U.S. jurisdictions have shifted toward mandatory electronic filing systems, which, while efficient, require a level of technical precision that can lead to costly delays if not handled correctly. The economic value of a mediated settlement is only fully realized once that document is converted into a judgment of divorce. Until that moment, the parties remain legally tethered, which can complicate everything from tax filings to the purchase of new property. To achieve a zero-friction filing, the first step is the technical audit of the Memorandum of Understanding. Imagine a character named Kevin in Miami. Kevin and his spouse successfully mediated their divorce in late 2025, reaching a comprehensive agreement on their diversified portfolio of real estate and tech stocks. However, they decided to handle the court filing themselves to save an additional $2,000 in legal fees. Because they did not use a standardized formatting template required by the Florida e-portal, their filing was rejected 3 times over a period of 4 months. During those 4 months, the value of one of their primary stocks surged. Because the divorce was not yet final, the stock was still technically a marital asset, leading to a new dispute over whether the post-mediation gains should be split. This administrative error potentially cost Kevin $40,000 in new negotiations and legal fees. The step-by-step detail for avoiding this involves the use of a pro se coordinator or a limited-scope document preparer. Many U.S. courts now offer a self-help center where staff can review your mediated agreement for procedural compliance before you hit submit. The goal is to ensure that every necessary form, the summons, the petition, the financial affidavits, and the proposed judgment, are perfectly aligned with the local rules of the specific county where you reside. By spending $300 on a professional document review, you are essentially buying insurance against the kind of delays that reopen the door to adversarial conflict. Once the judgment is signed by a judge, we enter the most critical window for wealth preservation, the 30-day post-mediation audit. This is the period where asset leakage is most likely to occur. Asset leakage refers to the slow drain of value through unmanaged accounts, forgotten subscriptions, or delays in title transfers. In 2026, the complexity of our digital and financial lives means that a standard divorce decree is just a set of instructions. It is not the execution itself. The first step in the post-mediation audit is the immediate title realignment. If the mediation agreement states that Kevin is to receive the 2024 Tesla and the primary residence, the decree itself does not change the title at the Department of Motor Vehicles or the county recorder's office. Historically, we see cases where individuals wait years to transfer a deed, only to find that a lien has been placed on the property due to the other spouse's subsequent financial issues. To lock in the financial gain, these transfers must happen within 72 hours of the judgment. This requires a coordinated effort, having the quitclaim deed prepared and notarized simultaneously with the signing of the final divorce papers. Next, we address the hidden economic drain of the joint credit line. Even if a mediation agreement states that one party is responsible for a specific credit card debt, the credit card company is not a party to your divorce. They still view both individuals as jointly and severally liable. If your ex-spouse fails to make a payment on a card that still has your name on it, your credit score will take the hit. The economic value of the audit is found in the systematic closing of all joint accounts and the transfer of balances to individual lines of credit. This might involve a temporary dip in your credit utilization ratio, but it protects you from the catastrophic risk of a former partner's financial instability. In 2026, where credit monitoring is instantaneous, a single 30-day delinquency can increase the cost of your next auto loan or mortgage by thousands of dollars over the life of the loan. We must also conduct a thorough life insurance and beneficiary audit. In many U.S. states, a divorce decree automatically revokes a spouse's status as a beneficiary on certain types of accounts, but this is not a universal rule, and it rarely applies to private life insurance policies or ERISA-governed retirement plans. Imagine if Kevin were to pass away shortly after the divorce without updating his beneficiary designations. Despite the mediation agreement stating the assets belong to his new trust or his children, the insurance company might be legally obligated to pay the funds to his ex-wife. This leads to years of litigation between the estate and the ex-spouse. The economic value of taking 2 hours to log into every portal, from the 401k to the term life policy, and updating those designations is immeasurable in terms of risk mitigation. Another layer of the masterclass involves the tax basis capture. When assets are divided, you must receive the cost basis information for every stock, bond, and piece of real estate you inherit in the split. If you receive a brokerage account worth $200,000, but you don't know that the original investment was only $50,000, you are sitting on a $150,000 taxable gain. Without the cost basis records, you cannot accurately plan for your future tax liability. In mediation, we insist that the production of these records is a condition of the final settlement. Capturing this data in the first 30 days prevents a situation 5 years down the road where you are paying a forensic accountant $3,000 to reconstruct records that your ex-spouse has since deleted. Consider the case study of the Cobra Health Insurance Bridge. For many American families, one spouse is a dependent on the other's employer-sponsored health plan. Upon the entry of a final judgment of divorce, that coverage typically terminates. Mediation allows the parties to negotiate who pays for the COBRA premiums for the 18 to 36 months allowed under federal law. However, the audit requires that the election forms be filed within 60 days of the qualifying event. If the ball is dropped, the uninsured spouse faces the risk of a medical bankruptcy event. In a 2026 economic environment where a single ER visit can exceed $5,000, the health capital of the family is just as important as the liquid capital. Step by step, the post-mediation audit should also include the digital vault transfer. This involves changing passwords on shared streaming services, cloud storage, and security systems. While it sounds like a social task, it has economic implications for identity theft and privacy. If an ex-spouse has access to your cloud storage, they may have access to your new financial statements, giving them an information advantage if they ever decide to seek a modification of support. As we conclude this segment on the technical and administrative lockdown of your wealth, we have to look at the new baseline. Once the audit is complete, you are no longer managing a marital estate. You are managing your personal net worth 2.0. But how do you grow that wealth after it has been halved by a divorce? In the next part, we will dive into the post-divorce investment strategy. We will look at how to rebalance a portfolio that was designed for a dual-income household into one that serves a single-income reality. We will also reveal the mediation clause for future disputes, a specific paragraph you must include in your final judgment that ensures you never have to pay a litigation retainer ever again, even if a conflict arises 5 years from now. How do you make your divorce litigation-proof? The answer is in the binding ADR provision. The binding ADR provision, or Alternative Dispute Resolution Clause, is the ultimate economic firewall for your post-divorce life. In the United States, the finality of a divorce decree is often an illusion. Life is dynamic. Incomes change, children grow, and relocation happens. Historically, these changes trigger a return to court, which lawyers call post-judgment litigation. Each return trip can cost a minimum of $5,000 to $10,000 in retainers. By embedding a mandatory mediation clause directly into your final judgment, you are legally requiring both parties to return to the mediation table before they are allowed to file a motion in court. This single paragraph effectively demonetizes future conflict. It ensures that if a dispute arises over a summer camp expense or a cost of living adjustment in 2028, the parties will spend $500 on a mediator instead of $10,000 on a court battle. To understand how to make your divorce truly litigation-proof, let us look at the case of a character named Sarah in San Diego. Sarah and her former spouse included a tiered dispute resolution clause. It mandated 3 specific steps. First, a good faith direct negotiation documented by email. Second, a minimum of 4 hours of mediation with a pre-selected neutral professional. And third, if mediation failed, a move to binding arbitration. In 2026, binding arbitration is becoming a preferred method for high-net-worth individuals to resolve post-divorce issues privately. Unlike a public courtroom, an arbitrator is a private judge whose decision is final and enforceable. But the process happens behind closed doors and on a much faster timeline. For Sarah, this meant that when her ex-spouse contested a change in the private school tuition 3 years later, the issue was resolved in 6 weeks for a fraction of the cost of a formal court trial. Now, let us transition into the economic reality of the post-divorce investment strategy. When you emerge from mediation, you are likely holding a portfolio that has been fundamentally altered. You may have more equity in a home but less in your 401k. Or perhaps you have been awarded a lump sum cash buyout in exchange for waiving an interest in a family business. The mistake many Americans make is attempting to manage this new, smaller pool of capital using the same strategy they used for a dual-income household. This is the moment for a strategic asset reallocation. In 2026, the economic environment requires a focus on liquidity and tax efficiency for single-head-of-household filers. Imagine if your marital portfolio was heavily weighted toward growth stocks because you had two salaries to cushion market volatility. Now that you are on a single income, your risk tolerance has mathematically shifted. Step 1 of the rebalance involves the creation of a 6-month liquidity bridge. Because you no longer have a second income to rely on in the event of a job loss, your cash reserves must be higher. In mediation, you may have fought for liquid cash precisely for this reason. Step 2 involves a deep dive into your tax filing status. Moving from married filing jointly to head of household or single changes your tax bracket significantly. You must look at the location of your assets. If you are in a higher tax bracket post-divorce due to alimony or a high salary, you might need to shift toward municipal bonds or other tax-advantaged vehicles to preserve your net yield. Step by step, you must also address the cost basis adjustment we discussed in the previous part. If you received a brokerage account in the divorce, you must immediately set up a meeting with a financial advisor to step up or track the basis of each individual holding. Historical trends show that individuals who fail to do this often pay an extra 15 to 20% in unnecessary taxes when they eventually sell those assets because they cannot prove the original purchase price. In 2026, automated tools can help with this, but it requires the initial manual input of the data you secured during your mediation audit. Consider the case study of the Social Security divorce benefit, a piece of the economic puzzle often overlooked in the United States. If your marriage lasted 10 years or longer, and you have been divorced for at least 2 years, you may be eligible to receive Social Security benefits based on your ex-spouse's earnings record, provided you are currently unmarried. This does not reduce your ex-spouse's benefit, but it can significantly increase your own monthly cash flow in retirement. A sophisticated mediation process includes an analysis of these future government-backed cash flows. If you are at year 9 of a marriage, there is a massive economic incentive to delay the finality of the divorce by 12 months to cross that 10-year threshold. A mediator who understands the long-term math of the U.S. Social Security system can help you structure a separation agreement that preserves this future wealth without requiring you to live under the same roof. Furthermore, let us analyze the economic value of the 529 college savings plan restructuring. In many divorces, these accounts are left in the name of one parent. However, in 2026, changes to FAFSA rules and tax laws mean that whose name is on the account can impact financial aid eligibility. Mediation allows you to split these accounts or create a successor-owner structure that ensures the funds are used exclusively for education, while protecting the assets from the potential creditors of either parent. This is another example of preserving the family's total economic engine. By coordinating on education funding, the parents avoid a situation where a child has to take out high-interest student loans while $50,000 sits in a contested account. The masterclass also covers the insurance arbitrage strategy. Often, a divorce decree requires the paying spouse to maintain a life insurance policy to secure their alimony or child support obligations. However, the cost of these policies can be high. In mediation, we look at the potential outcomes of using a decreasing term policy. As the total remaining support obligation decreases over time, the face value of the insurance policy can also decrease, significantly lowering the annual premiums. This saves the paying spouse thousands of dollars over the life of the support order, while still providing the necessary security for the recipient. As we approach the final segments of this deep dive, we have to look at the psychological transition from we to me in a financial context. This isn't just about mindset, it is about the economy of one. We will explore how to rebuild your credit footprint in the shortest possible time, and how to use the clean break principle to avoid financial ghosting, where old joint debts haunt you years later. But first, we must address a critical question. What happens if your mediation agreement is ignored? How do you enforce a mediated settlement without falling back into the very litigation trap you worked so hard to avoid? In the next part, we will break down the self-executing enforcement mechanisms. We will show you how to write penalties and triggers directly into your agreement that make it more expensive to break the deal than to keep it. We are going to look at the specific performance clauses that give your agreement real teeth in the year 2026. Self-executing enforcement mechanisms are the structural engineers of a durable divorce settlement. In the traditional U.S. legal system, If one party fails to follow a court order, the other must file a motion for contempt. This process is the opposite of economic efficiency. You must pay a lawyer to draft the motion, pay a filing fee, wait for a hearing date, and then spend hours in court hoping the judge will order the other party to comply. By the time the issue is resolved, you may have spent $5,000 to recover a $3,000 missed payment. In the year 2026, we utilize specific performance and liquidated damages clauses within the mediation agreement to ensure that compliance is the path of least resistance. Imagine a character named Christopher in Columbus, Ohio. Christopher is entitled to a $75,000 equalization payment from his former spouse following the division of their marital residence. In a standard agreement, if the payment is late, Christopher's only recourse is the court. However, in his mediated agreement, he includes a self-executing interest provision. This clause states that if the payment is not made by the specified date, a pre-agreed interest rate of 1% per month begins to accrue automatically, without the need for a new court order. Furthermore, the agreement includes a fee-shifting provision. This stipulates that if Christopher is forced to take any legal action to enforce the payment, the defaulting party is contractually obligated to pay all of Christopher's legal fees and costs. This creates a powerful economic disincentive for non-compliance. The defaulting party realizes that being late by even a few months could cost them an additional $10,000 in interest and fees, making the prompt payment a mathematical necessity. Another layer of enforcement is the use of the confession of judgment in jurisdictions where it is permitted, or the use of an escrow holdback. Imagine if Christopher's spouse was required to perform repairs on the home before it could be sold. Instead of taking her word for it, the mediation agreement requires that $5,000 from the initial house sale proceeds be held in a neutral attorney's escrow account. Once the repairs are verified by a third-party inspector, the funds are released. If the repairs are not done by the deadline, the funds are automatically released to Christopher to pay for the repairs himself. This removes the he said she said dynamic and replaces it with a mechanical financial transaction. The economic value here is the total avoidance of the post-judgment motion cycle, which historical trends show is one of the biggest drains on post-divorce wealth. We must also explore the concept of the automatic income withholding order, or IWO. While often associated with state-mandated child support, an IWO can be used in mediation for spousal support as well. By setting up the IWO at the time of the divorce, the support is deducted directly from the payer's paycheck and deposited into the recipient's account. This eliminates the monthly tension of waiting for a check and the economic risk of a missed payment. For the payer, it provides a clean record of payment, protecting them from false claims of arrears. In 2026, many U.S. employers have streamlined this process through digital payroll systems, making it a low-friction way to manage long-term financial obligations. Step by step, we also need to address the contingency of non-performance in parenting plans. While we have discussed the financial side, the time value of parenting is an economic asset as well. In mediation, you can include a right of first refusal clause with an associated cost-shifting element. For example, if the parent with scheduled time cannot be present for more than 4 hours, the other parent must be given the opportunity to take the child. If the parent fails to offer this and instead hires a babysitter, the agreement can stipulate that the non-compliant parent bears the full cost of that childcare without reimbursement. This aligns the parental behavior with the financial outcomes, reducing the likelihood of disputes that lead back to expensive mediation or court sessions. Let us look at a case study involving the division of private equity or carry in a 2026 context. Many professionals in the U.S. now have compensation packages tied to the performance of private funds. These assets are notoriously difficult to value and even harder to divide. In litigation, a judge might try to put a present value on future carry, which is often a guess that leaves one party overpaid and the other underpaid. In mediation, we use the Lynch versus Lynch, or in-kind distribution model. The agreement states that the non-employee spouse will receive a specific percentage of the net proceeds, if and when the carry realizes. To enforce this without future litigation, the agreement can require the employee spouse to provide annual certifications from the fund manager or the firm's CFO. By building in this transparency requirement, the parties avoid the information asymmetry that leads to distrust and legal threats. The economic value of these enforcement triggers is that they transform the divorce decree from a passive piece of paper into an active financial instrument. When you have a litigation-proof agreement, your mental bandwidth is freed up to focus on your new economy of one. This leads us to the crucial step of reestablishing the individual credit footprint. After a divorce in the US, your credit score may be artificially suppressed by the closing of long-held joint accounts, which reduces the average age of your credit history. A masterclass strategy for 2026 involves the authorized user bridge. If a party has a high-limit, long-standing credit card, they can temporarily keep the other spouse as an authorized user, without giving them a physical card, to help maintain that spouse's credit age while they build their own lines of credit. Alternatively, the use of secured credit cards or credit builder loans can help an individual return to a prime credit score within 12 to 18 months. The economic value of a 740 credit score versus a 640 score can be measured in the tens of thousands of dollars over just a few years of car insurance premiums, mortgage rates, and credit card interest. Furthermore, we must address the new household budgeting phase. In the first year post-divorce, many Americans experience lifestyle creep in reverse, where they fail to adjust their spending to their new single-income reality until it is too late. Mediation often involves the creation of a post-divorce pro forma budget. This is a forward-looking financial statement that accounts for the new tax filing status, the loss of shared housing expenses, and the cost of maintaining two households for the children. By modeling this out during the mediation process, the parties avoid the financial shock that often leads to a default on the very settlement agreement they just signed. As we move into the final part of this documentary, we are going to synthesize everything we have learned. We have covered the friction costs of litigation, the tax efficiency of mediation, the forensic transparency of voluntary disclosure, and the technical precision of the post-mediation audit. But the ultimate question remains: how do you know when you are truly done? When is the wealth finally secure? In the next part, we will reveal the final wealth preservation checklist. We will look at the long-term historical trends of mediated families versus litigated families and show you the success metric that proves mediation is the highest ROI decision of your life. We will also discuss the legacy transition, how to ensure that the wealth you saved from the divorce machine actually reaches the next generation. What is the one thing you must do on the first anniversary of your divorce to ensure your financial independence is permanent? The answer is the annual financial wellness check. The annual financial wellness check is the final cornerstone in the economic architecture of a mediated divorce. In the United States, the first 12 months following a legal separation represent a period of high financial volatility. This is when the theoretical math of the mediation table meets the hard reality of single household cash flow. By the first anniversary of your decree in 2026, the dust has settled on asset transfers and support payments, and you are finally in a position to measure the true return on investment of the mediation process. This checkup is not a legal requirement. It is a wealth preservation strategy designed to prevent the backsliding that often leads to a second round of litigation. Imagine a character named Linda in Charlotte, North Carolina. A year ago, Linda completed her mediation and walked away with 60% of the marital home equity and a modest spousal support bridge. On her first anniversary, she sits down to perform her wellness check. Step 1 is the support compliance review. Linda verifies that every payment has been received on time, and more importantly, that the taxes on those payments have been correctly handled. In 2026, the tax treatment of alimony remains a critical factor in the U.S. If Linda's agreement was structured under the old tax rules or specific state guidelines, she must ensure her withholding is adjusted to avoid a massive IRS bill in April. By catching a $300 a month withholding error in October, she prevents a $4,000 liquidity crisis in the spring. Step 2 of the wellness check is the asset performance audit. Linda looks at the brokerage accounts she received in the split. During the mediation, these were valued at a specific number. Now, a year later, she evaluates if those assets still align with her new risk profile as a single head of household. If she inherited a high-volatility tech portfolio but her primary need is now stable income for mortgage payments, this is the moment for a tax-efficient rebalance. Because she secured the cost basis data during the mediation audit, she can work with a financial advisor to sell underperforming assets while minimizing capital gains. The economic value of this anniversary audit is the transition from a defensive, splitting mindset to an offensive growth mindset. Historical trends in the U.S. suggest that the most successful post-divorce individuals are those who treat their divorce decree as a living business document. Step 3 involves the expense-to-income ratio analysis. In the first year, many individuals overspend on new furniture, legal cleanup, or emotional therapy. Linda compares her actual spending over the last 12 months to the pro forma budget she created during mediation. If she finds that her housing costs are consuming 45% of her income instead of the projected 30%, she has the data necessary to make a pivot, perhaps by refinancing her home or adjusting her discretionary spending, before she exhausts her emergency fund. This proactive management is what prevents the financial desperation that leads many people to sue their ex-spouse for more money, which only results in more legal fees for both sides. We must also discuss the legacy transition. For American parents, the ultimate goal of mediation is to ensure that the wealth saved from the legal industry actually reaches their children. In the first anniversary checkup, you must verify that your estate planning documents, your will, your living trust, and your power of attorney reflect your post-divorce reality. If you mediated your divorce but never updated your trust, you are leaving a massive economic trap for your heirs. In 2026, the cost of an estate dispute in probate court can easily reach $50,000. By spending $1,000 to align your new estate plan with your mediated settlement, you are securing the generational wealth you worked so hard to protect. Consider the case study of the escalation clause. In some sophisticated mediated agreements, there are built-in cost of living adjustments, COLA, for child support or alimony. On the first anniversary, the parties must look at the Consumer Price Index or another agreed-upon metric to determine if the support amount should shift. By doing this math annually and documenting it in a simple sign letter, the parties avoid the support erosion that happens over a decade of inflation. If support is $5,000 a month and inflation is 4%, the recipient loses $2,400 of purchasing power in a single year. The economic value of the annual check is the preservation of the real value of the settlement. Furthermore, we must address the mediation habit. Families who choose mediation for their divorce often find that the skills they learned, interest-based negotiation, transparent disclosure, and neutral facilitation, can be applied to all future financial disputes. If a disagreement arises on the first anniversary regarding the cost of summer camp or a new orthodontic bill, Linda does not call a lawyer. She calls her former spouse and uses the agreement to agree framework they established. If that fails, they return to their pre-selected mediator for a 1-hour check-in. This low-friction conflict resolution is the true secret to long-term wealth. When you spend $500 every few years to tune up your agreement instead of $20,000 every 5 years to fight in court, you are participating in a massive wealth-building exercise. As we conclude this deep dive masterclass, let us look at the success metric of mediation. In the United States, the success of a divorce is usually measured by who won the house or the custody battle. But the true economic success metric is the net worth retention rate. If a couple starts with $2 million and ends with $1.9 million after mediation, they have a 95% retention rate. If they litigate and end with $1.5 million, they have a 75% retention rate. Over a 20-year horizon, that 20% difference represents millions of dollars in lost compounding. The economic value of divorce mediation in the U.S. is the value of your future. It is the ability to walk away from a partnership with your dignity, your credit score, and your capital intact. It is a rejection of a system that profits from your pain, and an embrace of a process that prioritizes your prosperity. You have now completed the comprehensive masterclass on navigating the financial transition of a lifetime. You have the tools to spot the litigation traps, the steps to secure your assets, and the framework to protect your income. The final step is the most important. You must recognize that while the legal process ends with a signature on a decree, your financial journey as an individual is just beginning. The wealth you have preserved is the seed money for your next chapter. In 2026, the American economy is filled with opportunities for those who have the liquidity and the clarity to pursue them. By choosing mediation, you haven't just saved money on a divorce. You have invested in your independence. If you found value in this deep dive into the economics of the U.S. legal system, the next phase of our investigation is even more critical. We are going to step outside the realm of family law and into the world of private wealth protection. We will explore how high-net-worth individuals in the U.S. are using domestic asset protection trusts and specialized insurance products to shield their post-divorce estates from future liabilities. We will look at the Year 2 strategy for aggressive wealth building after the split. The door to your financial future is open. Make sure you are the one holding the keys.